Super Bowl Shuffle 4. The year in NFL-related intellectual property litigation. If you are a lawyer, there is a serious danger that someone at the Super Bowl party you attend is going to want to talk about an NFL-related legal issue. Did Cowboys owner Jerry Jones really have standing to challenge Commissioner Roger Goodell's salary package? Actually, we cannot help you with that question, but we can get you ready to discuss a recent NFL-related intellectual property dispute. IP certainly was not the biggest NFL legal story in 2017, but you will be hard-pressed to find another area of the law that has so consistently offered such a wide array of lawsuits pertaining to the sport. Our fourth annual Super Bowl Shuffle, a review of the year in NFL-related intellectual property dispute, is just what you need to get up to speed. So here's the game plan. Laminate this article and place it next to the carrot. There they are, those orange things because between the beer and the cake. If the game doesn't live up to the hype and you get bored, just pull out this article and tell your friend about some interesting football-connected IP cases. If you read quickly enough, you will be done just in time for the Patriots' inevitable fourth quarter comeback. No more sled and skin. This will probably be the last time we lead with the Washington Redskins trademark because Elvis has finally left the building on the particular issue. In June, the Supreme Court decided the landmark case of Metal Tam, which was brought by the Asian American band calling itself the Slam. The band's application to register its name as a trademark had been refused by the U.S. Patent and Trademark Office (USPTO) because Section 2 of the Lanham Act prohibited the registration of disparaging marks. The Supreme Court didn't decide whether the name was or was not disparaging, especially now that the Cleveland Indians are sort of abandoning Chief Wahoo, but it did hold that Section 2 prohibition that unconstitutional restraint on First Amendment right, thus opening the floodgates for the registration of all sort of offensive names, whether employed ironically or not. What does this have to do with football? The Redskins trademark, of course. Native American groups have been complaining about the team's name since the 1970s and litigating it since at least the 1990s. Amanda Blackhorse and other Native Americans used Section 2 to argue for cancellation of the mark because of its disparaging nature, and Blackhorse won, at least at first. Both the USPTO Trademark Trial and Appeal Board and the Eastern District of Virginia in pro football. Blackhorse agreed with her. However, while the team's appeal was pending before the Fourth Circuit, the Slant's case was decided by the Supreme Court. On January 18, 2018, the Fourth Circuit issued a game-over order acknowledging that the Supreme Court had decided the issue and vacating and the cancellation of the team's registration. The upshot, contrary to some reports, the team's ability to use the Redskin name and logo was never in doubt. As a practical matter, the only thing that the decision changed is that the team can now enforce the registered mark against infringers without worrying about a potential Section 2 cancellation counterclaim. In fact, only days after the Slant's decision, the NFL filed paperwork with the USPTO indicating an intent to challenge a Canadian entity's application to register Washington Red Nation. For sport-related clothing, now all the team needs is a quarterback and they are good to go for 2018. Trying to forget a gronking to remember. In 2014, Lacey Noonan self-published a Gronking to Remember, an erotic fiction in which a young couple's relationship is torn apart by a woman's sexual obsession with New England Patriot tight end Rob Gronkowski and the primal power of the Gronk spike. The original cover of the book featured a photograph of a young couple with Gronkowski goofily looming in the background. However, it turns out that Noonan didn't have permission to use the photo of the young couple. He simply obtained the photograph from a public social media website. The couple in question filed suit against the author and the book's online retailer. The complaint alleged that the Rose have been humiliated and embraced by their association with the book. Thank you.